I'm Matt Gishard, and this is No Holds Barred. In this episode, we're going to talk about jury verdicts, both civil verdicts and criminal verdicts in the state of California, and kind of how they work. Let's first talk about criminal. In criminal verdicts, in most states, and particularly in California, there has to be a unanimous verdict. Jury of 12, it's got to be 12, nothing. Anything less than that, it's a hung jury. And then the district attorney has to make a determination as to whether or not to retry the case, dismiss the case, or offer something lesser. And that happens all the time. It's interesting, the press oftentimes says a person was found innocent at trial. We don't have such a thing as innocent at trial. You're either guilty or you're not guilty. Well, what's the difference? Guilt means that a panel of 12 people found beyond a reasonable doubt that the person was guilty of whatever they're charged with. Not guilty means that the prosecution didn't prove beyond a reasonable doubt to the 12 panel members that the person was guilty. That doesn't mean that they were innocent. It simply means they were found not guilty. And that happens oftentimes. You think of somebody, I'll give you an example. When I was a prosecutor, in some cases somebody would be found with stolen property. And they are in receipt of stolen property, and there's a penal code section for that. But in some case I would see that, well, the prosecution had charged them with burglary because that property had been taken from a business, a store, a house, something such as that. You can see in that circumstance where, and sometimes they did it in the alternative. They did charge the person with burglary and receiving stolen property. Well, let's think about, from a defense attorney standpoint, how that might work. There's no proof beyond a reasonable doubt that that person actually went in and stole the property. So the burglary count should go up. That doesn't mean they didn't do it. That just didn't mean there's no evidence that they actually did it. Somebody else might have done it and given them the property. Number two, possession of stolen property. What is the critical thing in possession of stolen property? Well, number one, it's stolen property. Let's say they can prove that beyond a reasonable doubt. The owner says, no, I never gave permission. Somebody came in my store and stole that. Was it this person? Don't know. All right. But the person who has the property has to know that it was stolen property in order to be charged or convicted of possession of stolen property. Person says, guy came up to me and said, hey, you want this? I'll give you $10 for it. So I gave him $10 for it. I took it. I assumed it was all good, and I didn't realize it was stolen. Very difficult then to prove beyond a reasonable doubt that. That's the criminal side. Understand how that kind of works. The civil side is slightly different. It's not beyond a reasonable doubt. It's what's called, the standard now is called more true than not true. And it's just a 50% kind of a standard. Well, let's talk about a case, a civil case, and recently in the news we heard of Donald Trump. And that was a civil case where a woman a number of years ago held that Mr. Trump accosted her in a changing room at some store, sexually assaulted her. She called it a rape, and her lawyers charged in their complaint, not a criminal complaint, in a civil complaint, that in fact he defamed her, he sexually assaulted her, and he raped her. In that civil case, the standard is not beyond a reasonable doubt. So the jury in that case, after hearing the evidence, found that in fact he did defame her, and that's that 51% is all you need. And that's what the jury found. They found that he didn't rape her, but in fact he sexually assaulted her. And again, that civil standard, more true than not true. And what it said was, it didn't say, and this is where you kind of look at civil verdicts, it didn't say that he didn't rape her. It just says the jury could not find it more true than not true. And you think of kind of the fallback is here's a complaint count cause of action that is kind of in the alternative. Sexually assaulted her and raped her, you could kind of say it's the same thing, and they found the sexual assault rather than. But that's how it works in the civil side. Now, if it were a criminal side, and there is the potential, the statute of limitations is long past for Mr. Trump and Ms. Carroll on the criminal side, but had that case been brought a number of years before, there would not be the defamation action, there would simply be the sexual assault action, and that, or the rape, and that would have to be proved beyond a reasonable doubt. So that's kind of how that works. I do like to talk about trials because I think it's important that people understand what jurors have to do and what they don't do and how trials kind of work. One of the things the press often gets wrong in cases such as these that we're talking about, well, there are going to be opening arguments tomorrow morning. Well, let me say, in either a criminal case or a civil case, there's no such thing as opening arguments. They're opening statements. You cannot argue the case at the start. You simply state what you believe the evidence will show. And that's an opening statement, and they're generally limited. And if somebody gets up and starts arguing, there can be an objection, and the judge sustains it and admonishes the jury. That's argument. That's not evidence in this case. At the end of the case, now, opening arguments. That is the time in which the lawyers get to argue the case. They get to lay out for the jury what they believe the evidence that the jury's already heard says, indicates, and whatever, and they can argue. They can argue, look, this is what happened, and he said this, and she said that, and this is why you should find for us. The other side gets up, and you should find against us. In a criminal case in the state of California, because the burden is on the prosecution gets to go twice in closing arguments. The rule is they get up and give their closing argument. The defense gets up and gives their closing argument, and then the prosecution gets to get up. The rule actually is they only get to remark on those issues that are raised by the defense. So they're kind of closing argument, their second bite at the apple is just to remark on what the criminal defense lawyer said in his or her closing argument. Now, I often laugh and people say, well, so the prosecution gets 2 bites at the apple. I also used to get up, and sometimes defense attorneys would say that when I was a prosecution. Now, you're going to hear from Mr. Guichard. He gets to get up, and he gets to argue again. And I'd get up and say, well, you know, folks, the evidence is before you. If we didn't argue at all, the evidence upon which you decide this case is already before you, and that's what you decide the case on. So whether I get up 3 times or 4 times, or the defense attorney gets 5 times or 6 times, or as you see today, he has 1 time and I have 2, never mind any of that. It's the facts, the evidence, and you decide the case based on that. There's nothing unfair about the prosecution has the burden. That's a burden that they willingly accept. That's how it works in criminal cases. In civil cases, same thing applies. They cannot be opening arguments. In this last Trump thing, and I say Trump thing simply because that's a case that we just recently, everyone seems to know about, is the Carroll versus Trump matter. Opening statements, what they believe the evidence is going to show. Closing arguments. Now that's when they get up and say, hey, he said this in his deposition, he said that. That shows that he was aware of it or not. And the jury returned that, in fact, there was a defamation action. Remember, we've talked about that defamation. He actually made defamation, slanderous statements. He didn't write them. It wasn't libelous, it was slanderous, if you recall a couple of episodes ago. And interestingly enough, after that whole verdict, then the defendant in that case, who shall remain nameless, said it again, said a number of things disparaging and defamation, and guess what? Now there's another action and another complaint on the civil side for defamation again by Ms. Carroll. So interesting how that works in cases, interesting how things... In civil, I do want to talk about jurors. In civil in California, a verdict can be reached with a 9-3 vote. So in civil, it does not have to be unanimous. If it's 8-4, that's a hung jury. It has to be 9-3 or more. It certainly can be unanimous, 12. But in some cases, if it's 9-3, that's enough that the plaintiff prevailed in that 50% or more true than not true. In criminal, however, it has to be unanimous. Now, occasionally some juror gets sick in civil, some issue happens, let's say, and there aren't enough alternates, or there weren't any alternates, or they got sick and the case has gone on for some period of time and it's down to 11, somebody gets sick, it's only 11 jurors. The two sides can agree that, in fact, they will allow the case to go forward in state court by agreement, only 11 jurors. That's very unusual. We know on the civil side, in federal cases and in criminal cases, lesser numbers. Civil, sometimes it's, in federal, it's 6. But let's keep going with the state. 12 jurors, that's what we all think about, and unanimous for criminal, 9-3 for civil. And that's kind of the broad strokes of how these things generally work. So if you find this episode interesting, hit the like button, hit the subscribe button. It helps us with our YouTube algorithm.